Standing or locus standi determines whether a claimant has the legal rights to bring a judicial review. In the UK, the statutory basis is Section 31, subsection 3 of the Senior Courts Act 1981, which requires applicants to show sufficient interest in the matter. This test focuses on bringing balance between access to justice and preventing unfounded or meddlesome claims. The Fleet Street Casuals case molded the modern approach we have today. This approach is where the courts endorse a flexible and practical understanding of standing, linked to the rule of law and the need to hold public bodies accountable. The UK adopts an approach that is flexible, broad, and principle-driven, while Malaysia takes on a more narrow and restrictive approach, limiting the scope for public interest litigation.
The standing requirement in judicial review serves several important constitutional purposes. First, it performs a filtering role by ensuring that only claimants with genuine and legitimate interests may bring proceedings. Judicial review exists to challenge the legality of public decision-making, not to provide a forum for individuals pursuing personal agendas, ideological disputes, or conjectural complaints. As Jack Lee notes in A Place to Stand to Move the Earth, Standing and the Rule of Law 2020, standing rules must balance the desirability of encouraging people to participate actively in the enforcement of law and the undesirability of encouraging meddlesome interlopers from invoking the jurisdiction of the courts in matters in which they are not concerned. Without a standing threshold, the courts would be flooded with claims brought by busybodies, vexatious litigants, or politically motivated actors seeking to weaponize the judicial process. The requirement that claimants show sufficient interest therefore conserves judicial resources and ensures that the court's attentions are not focused on frivolous matters, but rather on issues of legality. At the same time, the standing rule also fulfills a crucial rule of law function. They must not be applied so rigidly that they shield unlawful acts of public authorities from legal accountability. As Lord Diplock warned in Fleet Street Casuals, an overly grave approach would create a grave lacuna in public law. He also emphasized that pressure groups, NGOs, campaign organizations, or even a single public-spirited citizen must sometimes be allowed standing, not because they suffer a unique personal harm, but because they play a vital constitutional role in bringing systemic or public interest illegality to the court's attention. This concept reflects the understanding that judicial review not only serves private interest, but public interest as well. Thus, the standing requirement must balance its filtering role with the constitutional responsibility to ensure that unlawful executive action can be brought before the court whenever necessary to uphold the rule of law. Furthermore, the standing requirement also plays a constitutional role in maintaining balance between the judiciary and executive. It serves to preserve the separation of powers by prohibiting courts from intervening where the issue concerns political matters such as decision on taxes and policies that will be better resolved by parliament or ministers. Courts should only intervene where a public authority has exceeded the limits of its legal powers. Requiring a claimant to show sufficient interest helps to prevent judicial overreach while still enabling the legitimate scrutiny of unlawful executive action.
The concept of standing in the United Kingdom has gone through significant change, evolving from a restrictive, private rights-based doctrine to a more flexible and public interest-oriented approach. This development reflects the growing recognition that modern administrative law must follow individuals and groups to hold public bodies accountable, even where the claimant does not possess a direct personal interest. Traditionally, the UK adopted a narrow approach to standing, particularly before the 1970s. Under this model, only individuals with a personal legal right or specific private interest affected by a decision could bring a claim for judicial review. This restrictive doctrine is exemplified in the case of R and Tottenham Justices Ex Parte North London Railway Co. 1874, where standing was limited to those whose own rights were directly infringed. As a result, the courts did not entertain claims brought on behalf of the wider public, effectively excluding public interest litigation. The underlying rationale was that judicial review should not become a forum for abstract or political disputes and should remain confined to dealing with issues that are affected by a person directly. However, from the late 1960s and onwards, the courts slowly began to take a more flexible stance, as they recognized that strict adherence to the personal rights model might prevent important issues of legality from being scrutinized. A pivotal moment in this transition was in the case of R and GLC Ex Parte Blackburn, 1968, where the court acknowledged that a concerned citizen should have sufficient standing to challenge a public authority's failure to enforce the law. Although the claim ultimately failed on the merits, Lord Denning emphasized that the rule of law sometimes requires the courts to hear challenges brought not for private gain but in the public interest. This case started the shift towards accepting that individuals may be well placed to bring proceedings to ensure public authorities act within their legal powers, even if they are not personally affected. The courts increasingly recognize that an overly restrictive approach should shield unlawful administrative action from review. This evolution laid the groundwork for broader standing rules under the modern judicial review framework, reflecting a more pragmatic and democratic vision of accountability. As Poole observes, recent years have seen a reconfiguration in the discourse and norms of English judicial review. The terminology of Wednesbury unreasonableness and ultra vires seems on the verge of being superseded by the language of rights and proportionality.
The turning point in the modern law of standing was crystallized in Inland Revenue Commissioners and National Federation of Self-Employed and Small Businesses, which was the famous case of Fleet Street Casual, a case that revealed two competing conceptual visions of local standi, one cautious and interest-based, the other more openly rule of law-driven. The majority, led by Lords Wilberforce, Fraser and Roscoe, adopted a restrained approach. They emphasized that a taxpayer generally lacks any legitimate ground to challenge the tax affairs of another, insisting that an exaggerate of individuals, each of whom has no interest, cannot of itself have an interest. Yet, this statement, while often quoted as symbolizing a conservative stance, was not the end of the story. The majority simultaneously accepted that certain exceptional circumstances, particularly where serious illegality is alleged, might justify granting standing to parties who otherwise appear unconnected to the dispute. Their reasoning left constitutional space for a more flexible and purposive doctrine, a space that later cases would expand. Modern scholarship has recognized this shift, noting that standing is no longer governed by rigid categories but is instead sensitive to context. As Bell observes, standing is now commonly treated as context sensitive. In sharp contrast, Lord Diplock articulated a far more liberal vision of locus standi. He warned that excluding public-spirited actors from judicial review would produce constitutional harm, stating that it would create a grave lacuna in our system of public law. If pressure group or concerned taxpayers were prevented from challenging unlawful executive conduct. For Diplock, judicial review exists to uphold legality, not to protect private rights. Therefore, standing should not operate as a technical barrier that allows unlawful administrative action to escape scrutiny simply because the most directly affected person is absent, unaware, or incapable of litigating. His approach reframed locus standi as a vehicle for the enforcement of the rule of law, not merely a filter of identifying private interests. Nevertheless, Diplock's vision has also attracted academic caution. Carol Harlow famously warned that opening the gates too widely risks inviting political contestation into the courts, arguing that allowing the campaigning style of politics to invade the legal process may undermine qualities such as certainty, finality, and judicial independence. Including this critical perspective reveals the constitutional tension at the heart of standing. The need to preserve the judicial process from political overreach while ensuring that legality does not go unchallenged. This tension makes Fleet Street Casual case not merely a doctrinal turning point, but a philosophical one. Despite the majority technical rejection of standing in that case, Fleet Street Casuals ultimately become the foundation of the UK's modern liberal approach. Courts in later cases drew upon both the majority recognition of exceptional illegality and deep law's rule of law rationale to expand standing for public interest groups. Decisions such as RV Foreign Secretary XP World Development Movement and RV Inspectorate of Pollution XP Green Space illustrate this evolution. NGOs were granted standing because of the importance of the issue, the absence of alternative challenges, their expertise, and the need of judicial oversight of governmental power. Contemporary academic analysis confirm that modern standing is not assessed in isolation from these merits. This demonstrates a shift from a rigid interest-based doctrine to one grounded in the constitutional function of judicial review. Taken together, Fleet Street Casual marks the moment when UK standing law moved away from narrow private interest tests towards a more principled and purposive model. By balancing the majority caution with deep law's commitment to legality and informed by academic warnings about judicial politicization, it laid the groundwork for the more open, flexible, and context-driven doctrine now characteristic of the UK system.
What is standing and why it matters? Standing, locus standi, determines who is entitled to bring a judicial review claim. It is to ensure that the courts adjudicate only genuine public law grievances while preventing abuse of court process by those with no legitimate connection to the matter. Standing in the UK was narrow, individualistic, and closely related to private law concepts of rights and interests. But now, the trend is a liberal and public-based interest approach to uphold the rule of law. In R and Inland Revenue Commissioners ex parte National Federation of Self-Employed and Small Businesses Limited 1982, the judgment liberalized the rules for standing in judicial review, moving away from the strict requirement of showing direct harm and allowing for a more flexible approach. This was a significant development in English public law, establishing a more accessible path for judicial review for groups with a genuine interest in a matter of public concern, as stated by Maheshwar Nath Chaturvedi in liberalizing the requirement of standing in public interest litigation. Lord Jennings and Ackner, LJ, emphasized the relationship between standing and legality. So far, the issue of standing has been considered as merely a threshold issue, and in determining this, the issue of legality or justiciability of the action was not taken into consideration. Now, it is being suggested that standing should be liberally granted if the action happens to be illegal and the issue justiciable. In pre-1977, the strict and rights-based approach, before the reforms introduced by the Supreme Court Act 1981 and the Order 53 procedure in 1977, the applicants had to show a direct personal interest similar to private law standing. At the moment, the public interest actions were mostly ignored and passed on. In R and Inland Revenue Commissioners ex parte National Federation of Self-Employed and Small Businesses Limited 1982, standing is not a preliminary hurdle, but it's linked to the merits of the claim, where the seriousness of the illegality is alleged and whether the rule of law requires judicial scrutiny. The modern approach in the UK. So standing is not a rigid threshold test. The courts could consider the seriousness of the alleged illegality, public importance and availability of alternative challenges. Standing and merits are interlinked, meaning that weak merits likely equal to no standing or otherwise. In the case of R and Secretary of State ex parte World Development Movement 1995, court had identified factors for granting standing: the gravity and importance of the issue, the likely absence of other challenges, the applicant's expertise, necessity for rule of law oversight, as well as in the case of ex parte Greenpeace No. 2, 1994. The factor for the case is granting standing is on expertise in environmental issues, representation of many affected individuals, need for informed, responsible litigation. But there are limits as well. In the case of R, Homecroft Properties and KPMG 2018, standing is not granted because the dispute was originally private or contractual, not a public law. The courts resist political, abstract, or academic challenges.
The modern law of standing in the UK reflects a shift from narrow rights-based judicial review to a more flexible, purposive doctrine centered on constitutional principle. It is to ensure that unlawful governmental actions does not escape liability merely because those most directly affected practically is incapable of litigating. Since the case of R and Inland Revenue Commissioners, ex parte National Federation of Self-Employed and Small Businesses Limited, 1982, the rule of law would be undermined if only the individuals with a personal or legally protected interest could seek review. The nature of standing today is contextual. Courts assesses whether the applicant has a sufficient interest by considering the seriousness of the alleged illegality, the importance of the issue, the applicant's expertise, and the need of an effective challenger. Therefore, NGOs such as World Development Movement, Greenpeace, and CPAG have been granted standing because they involve in enhancement of accountability, ensuring responsible litigation, and vindicates the constitutional legality.
Standing or local standby determines who may bring a judicial review claim in Malaysia. This balances access to justice with the need to prevent courts from becoming arenas for political dispute. Unlike jurisdictions that embrace broad public interest standing, Malaysia maintains a historically strict right-based approach. The foundation case on local standby in Malaysia is Government of Malaysia and Lim Kit Sang, 1988. In this landmark decision, the Federal Court adopted an exceptionally restrictive test. The court held that a person seeking judicial review must either demonstrate a personal right or a special interest in the subject matter. The court directly rejected public interest litigation, further stating that judicial review cannot be used as a general political platform. In this case, the appellant, who was a prominent opposition leader, sought to challenge the award for a government contract. The court later held that there was no standing as the appellant lacked personal or proprietary interest. The judgment prevents politically connected individuals or pressure groups to challenge government decision, as this would undermine the separation of powers and burden the courts with lots of political disputes. The strict approach has resulted in Malaysia to be amongst the most conservative common law jurisdiction on standing. Instead of treating judicial review as a mechanism to ensure government legality, the courts have decided to adopt a private law model focused primarily on personal rights. As Andrew Harding has described Lim Kit Sang in Law, Government of the Constitution in Malaysia, 1996, as a strong brake on public accountability, effectively closing the doors to public-spirited applicants and NGOs for decades. There are two main rationales that explain why Malaysian courts historically resisted broad standings. The first is fear of politicized litigation. Court expressed apprehension that the expanding standing would enable opposition politicians or activist groups to use judicial review for political purposes. Under this view, public interest litigation is at the risk of transforming into a battleground for political disputes. This concern is mainly focused in Malaysian political context, as executive historically exercise dominant authority and litigation often intersects with political disputation. The second reason is judicial philosophy, emphasizing on the separation of powers. Malaysian courts traditionally embrace a cautious, deferential stance towards the executive. The Lim Kit Sang decision reflects a judicial philosophy that prioritizes avoiding interference with governmental functions unless the claimant demonstrates a direct personal impact. This judiciary believes that it has a duty to stop roving commission of inquiry from making policies. Thus, this illustrates an institutional conservatism that favors restricting the judiciary authority in order to uphold what judges saw to be proper constitutional bounds. As a result of these rationales, Malaysian standing law was shaped to be more concerned about controlling litigation and maintaining institutional deferences by the rule of law, ideas such as ensuring legality or facilitating access to justice. Although Lim Kat Seng remains formally a binding precedent, more recent case law reveals a gradual and more cautious movement towards a more flexible conception of standing, driven in part by shifting judicial philosophies and increasing emphasis on the rule of law. In the case of QSR brands and Suruhanjaya Security and Anno 2006, it marks the first meaningful softening of the Lim Kit Siang approach. The High Court accepted the claimant may have a genuine interest in ensuring the legality of administrative actions, even where a strict personal or proprietary interest is absent. Although still far from public interest standing, the recognition suggested that the courts were beginning to move away from exclusively right-based model. In the case of Majlis Perbandaran Pulau Pinang and Syarikat Bekerja Sama, 1999, the decision pushed the law even further. The court acknowledged that individuals or bodies may seek judicial review and enforce public rights, and the absence of personal injury does not necessarily defeat standings. The reasoning reflects a growing awareness that excessive restrictions on standings can shield unlawful administration actions from scrutiny. Finally, in the case of Indira Gandhi, Anak Perempuan Motor, and Pengarah Jabatan Agama Islam Perak 2018, and other appeals did not directly address the standing test. The federal court reasoning is highly significant for Malaysian public law. The court forcefully reaffirmed that the principle of constitutional supremacy and the judiciary duty to ensure the legality of executive action. This shows a shift in judiciary attitude, as legality is paramount and courts must act as guardians of constitutional rights and process.
Despite sharing the same heritage, the UK and Malaysia have different approaches to locus standi in judicial review. The UK adopted the modern doctrine driven by rule of law consideration, since cases such as R and HM Inspectorate of Pollution ex parte Greenpeace No. 2 and R and Secretary of State for Foreign Affairs ex parte World Development Movement, standing has extended beyond just individuals with personal interests such as NGOs and pressure groups. Courts have recognized that such bodies often possess expertise, resources, and genuine concerns for the legality of public administration. This has led to the expansion of the sufficient interest test to ensure that unlawful government action does not escape scrutiny. Malaysia, by contrast, has adopted a more narrow and conservative approach. Landmark cases such as Government of Malaysia and Lim Kit Siang 1988 have established that only individuals with personal rights and special interests could bring judicial review claims. This decision was largely caused by fears of politicized litigation and a judicial philosophy that emphasized deference to the executive and a strict view of a separation of powers. A gradual, though cautious shift has occurred. In QSR brands Berhad and Suruhanjaya Security and others 2006, the courts accepted the claimant may have genuine interest in ensuring lawful administration. In Majlis Perbandaran Pulau Pinang and Syarikat Bekerja Sama Seberang Guna Sungai Gelugor dengan Tanggunan 1999, it further recognized recognition of public law rights, while Indira Gandhi, Anak Perempuan Muto, and Pengarah Jabatan Agama Islam Perak and others 2018 showed a renewed judicial commitment to the rule of law, even if it did not revise the standing test.
Gabara, Separation of Powers and the Growth of Judicial Reviews in Established Democracies 2015 provides a detailed analysis of how judicial reviews interact with the constitutional principle of separation of powers, making it extremely pertinent to the debate over standing in judicial review. The paper demonstrates how standing requirements have a crucial constitutional purpose by restricting the situations in which courts can get involved in executive or legislative decision-making. They are not only procedural obstacles. The assertion requiring claimants to show a sufficient interest helps avoid judicial intrusion into areas better left to elected authorities, like policy, decisions, or taxations problems. It is directly supported by this. Garbaram's study supports the idea that standing is an essential instrument for upholding the rule of law and constitutional bounds by linking the expansion of judicial review to the institutional requirement to maintain balance between the judiciary, legislative, and executive. The relevance of Varahu's article to the evolution of standing lies in the examination of how modern administrative law has shifted towards a more right-focused and accountability-driven framework, which underpins the court's increasingly liberal approach to standing. Varahus argues that English administrative law has undergone a reformation characterized by the court's growing willingness to scrutinize the executive action in the interest of legality and good administration. This broader, more purposive understanding of judicial review provides the doctrinal foundation for recognizing public interest standing, since a narrow private rights model would be inconsistent with a system that emphasizes the protection of constitutional principles and public law values. In this way, the themes identified by Varahus, such as the judicial commitment to upholding the rule of law and ensuring that public authorities remain within their legal limits, align closely with the court's shift from restrictive standing rules as seen in early cases like Tottenham Justices to a more open and flexible approach exemplified by Blackburn. The article therefore supports the view that the expansion of standing is part of a broader transformation in administrative law towards greater openness, accountability, and public interest adjudication. Lee's article is directly relevant to the constitutional purposes outlined because it frames the doctrine of standing as a critical intersection between judicial gatekeeping and rule of law accountability. The article explores how standing serves not only to filter out unmeritorious claims and preserve judicial capacity, but also to ensure that public authorities remain subject to legal oversight even when those bringing claims lack a traditional private interest. This dual role mirrors the argument that first, standing thresholds prevents courts being swamped by busybodies or ideological litigants, and second, that standing must remain flexible so that abuses of power are not shielded from review. By analyzing the evolution of standing under the UK's public law framework, Lee demonstrates how modern judicial reviews accommodates broader public interest claims such as those brought by NGOs or citizens litigants while still maintaining a rational boundary to judicial intervention. Thus, the article supports both narratives, the historical one of standing moving from narrow to liberal, and normative claims that it matters to the rule of law and institutional balance.
In conclusion, the UK's approach to locus standi has visibly developed from a strict and technical test to a more liberal and flexible standard where the rule of law and access to justice is prioritized. The decision in Fleet Street Casuals remains the foundational authority molding the modern understanding of sufficient interest. Though the UK courts now actively embrace public interest litigation as an essential tool for government accountability, Malaysia continues to apply a more restrictive approach. However, recent developments indicate a gradual growth towards greater flexibility. This contrast highlights differing judicial philosophies in balancing public interest and legal certainty.